Mr. Kounis, thank you for agreeing to give us this interview for the benefit of victims of Cyprus property mis-selling.
You're welcome.
Can you please explain what is a victim of Cyprus property mis-selling?
By definition, it is selling something based on misleading advice or information. In the cases of Cyprus purchases, these victims had all the odds stacked against them, from the way the system works in Cyprus, which allows off-plan sales against the developer's undivided title, to dodgy salespersons.
What exactly happened in Cyprus?
Well, it all happened during the last decade. Cyprus joined the EU in 2004 and the Eurozone in 2008. High growth was anticipated, particularly in the property sector. Alpha Bank, one of the largest banks in the mainland of Greece, had recently started operations in Cyprus, and we believe it was trying to muscle in to the market that was up until then led by the Bank of Cyprus, with Cyprus Popular Bank a close second. Alpha Bank pumped money into property development and sponsored off-plan sales by offering low-cost mortgages to buyers. The other banks retaliated, which resulted in reckless lending, hyperinflation of property values, and a buying frenzy. As far back as 2003, the Central Bank of Cyprus warned all banks to stop lending on property as they were creating a bubble. Lending in hard currencies, Swiss francs and Japanese yen, was another feature of this activity. In 2006, the Central Bank of Cyprus was alarmed by the fact that for the first time, lending in foreign currencies exceeded domestic lending, and warned all banks to stop this practice, which was very risky for the clients and was overexposing the banks. Throughout this period, circular after circular of the Central Bank of Cyprus was raising the alarm on breaches of the rules, including in particular loan-to-value ratios, and turning a blind eye to overinflated valuations. The central bank was consistently ignored, and the market allowed such excesses as 20 to 30% commission to sales agents, gifted deposits, and guaranteed rental agreements that invariably had already been built into the selling price, so that the purchaser was prepaying what he was being guaranteed. Worse still, due to the offer of these guarantees, the purchaser was lured into thinking that the anticipated rental income would far exceed the guaranteed amount. Nothing was further from the truth. The aftermath of all this was that purchasers were left with properties that are now worth 30 to 40% at best of the original purchase price. Most of them do not have title deeds, so they cannot sell them. A number of them had not even been completed, and their bank loans have swelled by at least 50% due to foreign currency losses and excess interest charges. In arrears have been pursued by the banks as bad debtors, and by far the worst abuse of the situation is that banks do not repossess the property. Instead, they pursue the purchaser as a debtor in his home country and try to seize his assets. And it is all done in a pretty horrific way. Recoveries officers demanding their money and denying all knowledge of how they got there. Debt collectors in the home country, court proceedings, and the like. A lot of these victims are suffering from stress, anxiety, or depression, what is commonly known in psychiatric circles as SAD, appropriately. There has been a breakdown of many relationships, not only amongst couples, but where people have bought jointly amongst friends and relatives, and there have been a number of suicides.
Sounds horrific. Surely the government intervened to sort it out.
Unfortunately not. The Cypriot developers, the Cypriot banks, and the Cypriot government saw little wrong in what happened and generally claim that purchasers should have been more careful. Having taken their profits and taxes out of the deal, they left purchasers stranded with an unwanted property and an unwanted loan. The British government has been paying lip service to the problem, but have failed to regulate even their own financial advisors who were involved in advising Britons on the purchase. It seems that cross-European regulation leaves a lot of gaps between the varying jurisdictions. And these bodies are not sure themselves what they should be regulating and what should be regulated by the regulators of the other country. The job, unfortunately, has been left to lawyers, and even this avenue has its problems. A lot of them only have litigation in their arsenal. The costs are enormous, and the rivalry is tense.
But are you not a firm of solicitors?
Indeed we are, but from day one, the firm realized that the traditional approach is not the answer. We needed to have a multiplicity of talents to deal with the situation, and this is the reason I was placed in charge of a team which includes lawyers and solicitors, but also includes people from differing skills, ranging from financial accounts to topography. Although we are in a competitive market, we're the first and remain the only firm that has invited collaboration between firms to face common opponents from a position of strength. Regrettably, the other English firms involved did not agree to form a Cyprus lawyer circle, and with Cypriot law firms, we cannot agree on jurisdiction. They want to try these cases in Cyprus, whereas we believe that our clients would fare better in a court at home. Luckily, a lot of victims realized what has been going on and have been joining us in droves. We're now by far the largest group with around 1,500 clients involving some 700 properties. But we're barely scratching the surface.
What do you mean? How many victims are involved?
Some estimates say 35,000. We believe that there are around 10,000 properties involved, so we represent less than 10%. And even if you add all the other groups together, only around 50% are represented.
This is unbelievable. Can you explain why that is?
There are a number of people who have already settled. Most of them have now come back to us to say that they did not realize how bad the deal was and whether they can reverse it. Fortunately, for those who settled dependently, they may be able to claim that they did not have legal advice before entering into that arrangement. The banks should have known better before they entice somebody to sign without legal advice. For those who belong to a group, a lot depends on the advice they did receive. Ultimately, it all depends on the facts, but we shall be happy to advise.
So they should consult you?
Yes. There are also a number of people who are waiting in the wings to see what happens. This is not very wise. The only thing that is certain to happen is that they will be time barred from claiming, and if you have not filed a claim, there is no legal obligation on your opponents to give you what has been awarded by the court.
So they need to file. What is the deadline?
Currently, it is 31st of December 2015, the end of this year, unless this is extended by the Cypriot Parliament, but we have already had 3 extensions so far, so I do not really see it happening again.
So they have a few months?
No, they have no time at all. The cost of filing in England is huge, unless you are part of a collective claim. We do not file collective claims often because we need to make up the numbers in order to justify the cost. Due to the numbers filing, a collective claim gets complicated and there are delays. So there is no time to waste. You really need to join now. In any event, if you're in arrears, the bank will take action and may have already done so. You need to jump in first and file. If they have filed first, you will be defending their action at high cost. If you file first in your home country, within the EU, the Cypriot court will have to respect them that another court within the EU has been seized first. But there is another reason why they need to file urgently, particularly if their loan is with one of the subsidiaries of the Greek bank, that is Alpha Bank and Poriki National Bank of Greece. Following the crisis in Greece, all Greek banks are expected to shed their subsidiaries in Cyprus and the Balkans. This has been on the cards for some time, but now it can no longer be held back. There is even talk of the 4 major Greek banks merging into 2.
How does that affect the victims?
These subsidiaries are already separating the good loan accounts from the non-performing loans, or as they are often referred to, the NPLs. The good accounts may be passed on, but the NPLs they will have to give away for a sum if anyone will have them. But there is a third category that I do not expect anyone to touch, and that is the category where the client has a substantial claim against the bank. I cannot see another bank wanting to take on that liability. These accounts, therefore, will have to the advantage over the rest.
So filing is imperative.
Absolutely.
What about filing in other jurisdictions outside England?
We do have our own offices in Scotland, and we're looking to collaborate with firms in Northern Ireland and in the Republic of Ireland. Where the victim needs to file in Cyprus, we do collaborate with certain law firms that will undertake the filing for us.
But going back to the numbers who are not represented, you were saying that some have settled and some have been waiting in the wings. Does this account for all the victims?
I believe that there is a large group that do not even realize that there is something they can do about it, and also another group that fear the costs involved.
You are saying that for this first group, more publicity is needed.
Yes. People need to become aware that there is indeed something that they can do instead of suffering in silence.
How do you intend to get the word out?
There has already been a lot of publicity, but thousands of victims have not been reached. The only way to reach them is by word of mouth. It is easy enough to share this interview on YouTube, but picking up the phone and speaking to purchasers within your complex can do wonders to bring these people on board.
What about the group that fear costs?
In most cases, it is a false economy. It is like someone who refuses to spend any money on fillings and then ends up needing a complete set of dentures. In fact, it is much worse. We have seen clients having to spend thousands defending a charging order or a bankruptcy order because they did not come to us soon enough to spend a few hundred on filing their claim before their opponents did. I cannot overemphasize the importance of jumping in first. And for our own fees, we have multiple choices, including knowing no fee. And soon we will be the only group able to offer litigation funding.
How does litigation funding work?
Actions against powerful opponents can cost millions. This is why they seem to always win, because powerful litigants tend to try to outspend their opponents. The weaker opponent runs out of money. Having a litigation funder on board levels the playing field. The funder takes the risk and part of the award. Opponents then know that the possibility of running out of money no longer applies, and they will have to consider their case on merit, not on tactics. It is not easy to get litigation funding on board, but being the largest group and with the potential of becoming a unified single group, we have agreement in principle, and we are currently working on the terms. In any event, a large group can near enough afford self-funding, as the cost per case becomes so much less. So it makes sense for everyone.
So you are saying that numbers are important and victims should unify and fight this totally united?
Absolutely. These victims have suffered in the hands of their opponents, in the hands of those they sought remedies from, and are now suffering because they remain disunited. Winning these cases is a no-brainer. You need the numbers. It is numbers that can carry a collective action. It is numbers that can secure the funding. It is numbers that can command the negotiating power needed to deal with banks that are selling their assets. It is numbers that give us the muscle to demand a lot more for these victims than what the banks have been willing to offer. It is numbers that can fund litigation.
Mr. Kounis, thank you once again for your time. You have given a lot of useful advice, and I sincerely hope that whoever is watching takes note.
Thank you.